Court is calling 2025 CR 011411 and 2023 CR 8904, State versus Tanya Arteaga. Can I have parties announced?
Lauren Espinoza for the state.
And Jonathan Alvarado for the defense.
And are you Miss Tanya Arteaga?
Yes, Your Honor.
All right, we're going to start with the motion to revoke.
Very good.
Did you review motion to enter adjudication of guilt and revoke community supervision and First Amendment motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Tanya Arteaga who was placed on deferred adjudication in 2023 CR 8904 for the offense of aggravated robbery on December 11, 2023 for a period of 8 years? Is that you?
Yes, Your Honor.
All right, state.
Judge.
Yes.
I believe this was heard actually, and she pled not true.
So Judge,
She did. All right.
Sorry, Judge.
So do you have witnesses?
Yes, Judge.
All right.
So judges, we are, with the court's permission, asking to change her plea of not true to true. When I was here last time on this case, Judge, I was just appointed to the MTR. She has a new number 1 that I was not appointed to. At the time that we were here, that was the only allegation against her. And so Judge Angelini was sitting on the bench. He agreed to appoint me to the number 1 and give me 10 days to prepare, but also asked that she enter her plea at that time of not true. And so that is what we did, Judge, with potentially the expectation that she could come forward today and change her plea to true, which she has the intention of doing, as well as pleading to her new case as well.
All right. So are you asking to withdraw your plea of not true?
Yes, Your Honor.
All right, state, you may proceed.
Violated condition number 1, on or about the 8th day of August 2025 in Bexar County, Texas, the defendant Tanya S. Ortega committed the offense of theft of materials, aluminum, bronze, copper, brass, less than 20,000 in violation of condition number 1.
How do you plead to that? True or not true?
True, Your Honor.
And state, do you waive other violations?
Yes, Your Honor. State waives the remaining violations.
Any objections to the waiver?
No objections, Judge.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to life in prison and up to $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 1? Court will find violation of condition number 1 true. Is there a proposed agreement?
Yes, Your Honor, the proposed agreement is to revoke revoke community supervision, enter an adjudication of guilt, sentence 5 years to do, and then run concurrent with the new theft offense.
Are you asking the court to follow that agreement?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
And defense, is this the agreement you're asking the court to follow?
Yes, Judge, we are.
Has she done anything on probation?
She has, Your Honor. She was employed working as a welder for, I believe it was not to be a plant per se, but maybe one of their subsidiaries, Judge. I believe she had many submissions as far as drug tests. However, she did have a few missed, but she was not testing positive. She had recently gotten out of prison, and she also has some pending case in Uvalde County, Judge. She was on GPS monitor for a long time out of her probation for this court. She was making payments towards that. She was also on pretrial at Uvalde County, having to make payments towards that. She got into a position, I think, Judge, where she was financially unstable, leading to the theft charge that's before you now. Ms. Ortega has not tested positive, and I don't believe the theft was drug related, Judge, as far as like trying to make money to pay for drugs. I think it was something where she was trying to have money to pay for rent and so on. And she makes those kind of admissions in the stipulations on the theft case. So this was something, Judge, where we actually considered potentially going open to Your Honor to continue to see if you consider continuing her on probation. But given everything that was going on in her cases, being also on a parole hold, this was something we came to an agreement with the state for. We are asking you to follow it.
All right, so the underlying facts of the case that she's on deferred adjudication for are not great.
Yes, Judge.
So this is what the court is going to do. The court is finding violation of condition number 1 true. The court is going to find you guilty, revoke. The court is going to sentence you to 8 years in the prison, give you credit for any time served. There's an affirmative finding of deadly weapon. There's to be no contact with Michelle Young. No residing with minors.
When Your Honor can, I have one more request regarding this
Yes.
case. So she does have parole hold out of Bell County.
Mhm.
Affecting the court's sentence, we would ask that if the court would consider running that case concurrent with this case, and I do have the cause number on that.
All right, concurrent with,
Bell County case number FR 81006.
006.
Yes, Your Honor.
All right, and what the court will say is with regards to that cause number, she will only receive credit if there was a warrant issued in this case and if she was in custody for the Bell County matter.
Okay, Judge.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? You have a limited right to appeal. That right to appeal is as it relates to the allegation in the motion, not the fact that you were on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, let me put this in the system, then we'll move on to the next matter. All right, next we're moving on to the 2025 CR 011411. Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge, I did.
Court will find that the state is in compliance with discovery.
Thank you, Judge. I didn't sign it. Okay. Very good.
All right. Then she needs to sign it. It
Sorry,
happens.
Judge.
No
How
problem.
much paperwork? This is restricted.
Thank you. Did you review the document entitled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure?
Yes, Your Honor.
Do you understand that your attorney has certain rights? Namely, your attorney has the right to have the passage of 2 days upon presentation of the information in 10 days to prepare for trial?
Yes, Your Honor.
And also you have certain rights, that being that you have a right to have a grand jury review the evidence in this case and make a decision on whether or not to indict.
Yes, Your Honor.
By entering this plea bargain agreement, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information on and rights under Article 26.03 and 1.051. Did you review the felony information with your attorney? Did you understand it?
Yes, Your Honor.
And we're proceeding on the information as presented, counsel?
Yes, Judge.
And you're waiving the reading of the information?
We are, Your Honor.
All right. And states you're proceeding on the information as presented?
Yes, Judge.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
All right, you're charged with the offense of theft of material of copper from Home Depot as a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Miss, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Do you understand if you're not a U.S. citizen, by entering into this plea, you can be deported, not allowed re-entry into the United States, and denied naturalization?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed under 1244 to 41 days in the Bexar County Jail. There's $1,000 fine. This will run concurrent with 2023 CR 8904. Did you understand that to be your plea?
Yes, Your Honor.
Defense,
Yes, Judge.
state.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
There have not, Judge.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
Yes, Your Honor. States Exhibit 1 and all attachments.
No objections.
All right, state, you may be excused.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
As we ask, to follow the plea bargain, Judge.
All right, this is what the court will do. The court will find you guilty, sentence you to 41 days in the Bexar County Jail under 1244, give you credit for any time served. There's $1,000 fine. Time and money will run concurrently. This will run concurrent with 2023 CR 8904 with a cause number in Bale County FR 81006. There's to be no contact with Home Depot and no contact with Lydia Angel Hernandez. Did you review the documents entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we're gonna go off the record. Good luck to you. You're gonna have to
Thank
make
you.
better life decisions, all right?
Yes, ma'am.
All right, good
Thank
luck.
you.
So where are we on discovery?
Judge, I believe I have everything. If I need to sign a discovery acknowledgement, I can certainly do that. This is a first setting, it's first opportunity. I've spoken with Lauren. There may be a suppression issue, so she and I are going to kind of do a little research. I was asking the court for a 30-day reset so that we could find out how I'm going to proceed, if that's okay.
Okay, Mr. Cobbs.
I know you run a tight ship.
I can smile and laugh because your attorney and I know each other.
That's a good thing.
He says that's a good thing, Adam. All right, so I'm gonna recall this back for a plea deadline date. It is gonna be a plea deadline date, or either you all going to be ready for a motion to suppress. We will set this for October 20th. Is that a good date for you, counsel?
Judge, I don't have my calendar on me, but if there's any big issue with it, can I get with Norma?
Yes.
So October 20th, that'll be a plea deadline or
Or-
a motion to suppress.
Yes, so you'll need to make sure you let the state know well in advance that it's going to be a motion to suppress.
Understood, Your Honor.
Okay. All right, once you get the reset form, you and sign it, you're excused.
Thank you.
You're
Thank you,
welcome. Thank you. All right, who's next? Who do you have next? Francisco de la Rosa. All right, is this your first time in court?
Yes, ma'am.
All right, so in this court, docket is at 9, so you need to make sure you're on time, you understand?
Yes, ma'am.
All right, so where are we on discovery?
We have what we need, Judge.
And was there an offer tender?
It was.
And how old are you?
21.
All right. Recall this for October 21st for a plea deadline date. That'll give you a chance to discuss options with your attorney. Once you sign the reset form, you are excused, and thank you for dressing appropriately for court.
Welcome.
Thank you. Just have a seat and your attorney will bring the reset form to you. Who else do we have? Raymond, are you not in jury trial somewhere?
We're supposed to pick right now, Judge. Across the hall.
Oh, okay.
It's working out.
Oh. Felix Beltran. Hello, Mr. Beltran.
Hey, going, man.
All right, I'm waiting for Odyssey to pull up his case.
Judge, while you're waiting for that, he was actually set Monday, but I had filed notice a little while back. I didn't get the setting and we checked this morning. Looks like there was an IT issue with me getting recognized as the attorney or me
Okay.
getting my settings. I came in and Nora moved him to today, to recall him today, but I could be here. And in addition to those problems, I think this takes us for the time.
All right, so what we'll do is we're going to recall this on the same date as your previous client, October 21st.
Actually, Judge, we're working on potential pretrial motion on this bond situation.
Okay.
If I get that file, should I set that or can?
If you get that file, just speak with Ms. Ferguson and she'll put it on the docket ASAP.
Okay.
All right, so beyond that, your reset date is going to be October 21st. And if your attorney wants you brought back sooner for any motions to be heard, he just needs to request it, okay?
Yes, ma'am.
You have any questions about anything?
No.
All right, thank you.
Thank you, ma'am.
All right, who's next? Juan Rivas.
Morning, Judge.
Good morning. Are you not in trial?
I am in trial. I will tell you about that.
Okay.
Judge, we're just looking for a reset. There's still more discovery.
All right, what is the outstanding?
I saw in the state's file this morning some notes that I'm sure have been uploaded, but I haven't read them yet.
All right, I know you're currently in trial and I do believe 88 Jones is in trial.
We are, Judge.
We're both in trial.
Mine is a steel trap. I think you guys both are in trial. So I can recall this. This will be the final discovery.
Okay.
I can recall it for October 21st.
That could work, yes.
All right, you'll come back on October 21st and that'll be final discovery. Once you
Yes, sir.
sign the reset form, you're excused.
Yes, sir. Thank you.
Very okay.
Thank you, Judge.
All right, thank you. Anyone else? And everyone, the court is recessing exactly at 12 because we have a jury trial and the staff needs a break. So if your matter is not taken up forthwith, you're gonna come back on Monday.
Your Honor,
Yes,
mine will take a little longer. Would I be allowed to have my client excused to Monday? And I'll
what is
still,
your client here for?
it's unauthorized use of a vehicle, state jail. It's one case, Lamar Simmons. And I've been conferring with Lauren and there's a
Okay,
rest.
you'll have to get in line, have them mark you down. We don't have any files anymore, so we have to do it this way.
I'm up there on the right.
Okay. All right, who's next? All right, who's here on the Briam Mahia?
Present, Your Honor. Ashley is also involved,
Is there more than one case?
no, just one.
All right, so is there a prosecutor who's available to take a plea? Rick. All right, court is calling 2025 CR 002415 State versus Briam Mahia. Can I have parties announced for the record?
Roger Bettis for Briam, Your Honor.
And are you Mr. Mahia?
Yes, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, it appears.
Well, actually, there is just a slight modification in the indictment to change the word to a victim.
What?
I apologize, Ashley.
What do you mean change the word to victim?
I think there was, on the last page, there was a document on just a slight modification. It may be best to have Ashley here just to make it proper for the record.
Texted him.
All right, so what I can tell you all is in the indictment, there's not a pseudonym that's listed.
And that's what the changes, but that's what the issue is. Just want to make it proper for the record. That's the only issue.
All right, so for the record, the indictment doesn't have the name of the pseudonym, but the court does have a copy of the pseudonym with the name and the pseudonym attached. So it's the court's understanding that you're proceeding on count 5 only. Is that correct?
Yes, Your Honor.
All right. Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your
All right. You're charged in count 5 according to the plea bargaining. According to what you're charged with, the range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promise you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
No.
Oh, I'm so sorry. I wasn't supposed to ask that. Here's the thing. If you're not a United States citizen, by entering into a plea in this case, you will be deported. You will not be allowed reentry into the United States, and you will be denied naturalization. Did you understand?
Yes, Your Honor.
Counsel, did you want to address any immigration issues for the record with regards to your client?
Judge, we have addressed those issues regarding his immigration consequences, and he fully understands the impact of this case on his immigration status.
All right, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on count 5. Punishment is to be assessed at 5 years in the prison. There's a $1,500 fine, no applications, Chapter 62 compliance, and you have lifetime registration, and there's to be no contact with the complainant. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
It is, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Then to count 5 in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor. This unsealed on the evidence, it's exhibit 1 with all attachments.
No objections, Your Honor.
Did you review the waiver of appeal, the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? You need to speak up.
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Ashley Jones for the record, and yes, Your Honor.
Yes, Your Honor.
Right. And state, have you talked to the complainant?
We have extensive.
And are they in agreement with this?
Yes, Your Honor.
All right. After reviewing the exhibits, as the court previously stated, the court is finding you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Just, he understands the impact that he's had on the lives of all his family as well as others, and he just wants to move forward on this.
All right. Court will sentence you to 5 years in the prison. Give you credit for any time served, because legally I must give you credit for any time served. There's a $1,500 fine. Time and money will not run concurrently. Chapter 62 registration. There's to be no contact with minors, no contact with the complainant, and no re-entry into the United States. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Right, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal, because this is a felony conviction. You're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record.
All right, let's talk about that. This Texas hearing for Tanya Arteaga and Brian Mahia gave us 2 very different stories, but both reminded us how plea agreements, probation violations, and sentencing all come together in real time. Judge Ferguson kept control of the courtroom with her usual mix of professionalism, careful explanations, and no-nonsense rulings was Tanya Arteaga, who had been on deferred adjudication for aggravated robbery. Things unraveled when she picked up a new theft case: aluminum, copper, and brass taken from Home Depot. Originally, she pled not true to violating probation, but after working with her attorney, she changed her plea to true. The state waived the other violations, and both sides recommended revoking her probation and sentencing her to 5 years, concurrent with the new theft offense. Her lawyer pointed out she had held down a welding job, tested clean on drug screens, and was financially strapped when the theft happened. He even floated the idea of continued probation, but acknowledged the weight of her parole hold and prior history. Judge Ferguson wasn't persuaded to extend leniency. She emphasized the seriousness of the underlying aggravated robbery, revoked her probation, and imposed an 8-year sentence, concurrent with her Bell County case and with a deadly weapon finding attached. The tone here was heavy. Arteaga seemed resigned, her attorney realistic, and the judge unwavering in her decision. Then to Brian Mahia, whose case carried a different kind of weight. He pled no contest to a count in his indictment with a plea agreement for 5 years in prison, a $15 fine, and lifetime registration requirements. The judge carefully walked him through every right he was waiving, from jury trial to confrontation, and double-checked his understanding of the immigration consequences. Since he wasn't a U.S. citizen, this conviction guaranteed deportation. Mahia acknowledged it all, and the state confirmed the complainant had been consulted and agreed with the deal. His demeanor was quiet and cooperative, his attorney assuring the court that he understood the gravity of the outcome. Judge Ferguson accepted the plea, imposed the 5-year sentence, and emphasized the restrictions: no contact with minors, no contact with the complainant, and compliance with lifetime registration. It was clear, precise, and firm. The overall atmosphere was serious, with very little room for humor or levity. Arteaga's case showed the court's limits. Probation can only stretch so far when new offenses pile up. Mahia's case, meanwhile, underscored how plea bargains work when the stakes include not just prison time, but lifelong restrictions and immigration consequences. Through it all, Judge Ferguson stayed composed, explaining the law in plain terms and ensuring no one left confused about what had just happened. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.